Assalamualaikum. We are in a new chapter of company law. We are looking into promoters and pre-incorporation contracts. So at the end of this lesson, you are expected to identify or know who is a promoter, and you should be able to explain their duties and remedies if the promoter breaches duties. And you should be able to define what are pre-incorporation contracts, the effects of pre-incorporation contracts, and differentiate between the position of pre-incorporation contracts in common law and in Malaysia. Okay, now when we talk about promoters and pre-incorporation contracts, we're going to look into the promoter itself, his duty, and we're going to look later on the pre-incorporation contracts. Now, who is a promoter? What does it mean by promoter? Now, bear in mind, when we said a promoter, they are not those promoters whom we find in the shopping complexes, and the one who actually promote shampoo, skincare products, beauty care, all those vitamins. They are also promoters, yes. But for our purpose, promoter are those person involved in the formation of a company. And basically, historically and even until today, they are the one who enter contracts on behalf of company before that company receive its certificate of incorporation or before that company receive its notice of registration. Now, Section 2, Subsection 1 of the Companies Act defines promoter. As far as we are concerned, that particular definition actually relates to a prospectus. So there is no direct definition as far as promoter is concerned under the Companies Act 2016. Now, since the definition under the Companies Act is not that clear as far as promoter is concerned, perhaps we can look at the definition given by the cases. Now, we can look into the firstly in the case of Tui, Cross and Grant, whereby in this case, the owner of a concession wished to form a company. He engaged a person to assist him in the formation of the company, together with a contractor who were to provide the finance. Now, the court held them that they are the promoters. Chief Justice Cockburn said he defined a promoter as the one who undertakes to form a company with reference to a given project and set it going, and who takes the necessary steps to accomplish that purpose. So, based on that particular definition, so basically a promoter is a main person who makes it going, who really start off before that particular company is incorporated. Okay, now in the case of Tengku Abdullah Sultan Abu Bakar and Muhammad Latif Shah Muhammad, Justice of the Court of Appeal Gopal Sriram said a promoter is one who start off a venture. It can be any venture, not for himself but for others, of whom he may be one. So basically, it can be anybody who start off the business. He did it for himself, or he might not do it for himself, but he may be do it for someone else. So that is what we call promoter. Now, we can actually classify these promoters. Basically, promoters can either be natural person. Okay, one good example is the Solomon case. Mr. Solomon, who himself opened up another company. Now, or he can be an artificial person, as in the case of a setting up of a wholly owned subsidiary by a holding company. So, it either can be natural person or artificial person. Now, when we talk about the promoters, okay, we can see that there are actually active promoters and passive promoters. So, active promoters are person who actually bring that company into existence. So, they can actually taking part, or they can procure somebody to actually join them, sign agreement, sign any contract. These are active promoters. You can see from the case of Will Allen, Gold Mining and Reed. Or if you want to know who are passive promoters, you can see in the case of Tracy and Mandalay, where promoters can also include those who do not take any active role in the promotion of a company but leave the promotion of their company to others on the understanding that he or she is to profit from the promotion of the company. So basically, you just leave it to someone else to do it on your behalf. All these active getting cases, getting projects, getting contracts, these are, and you are also promoters, but you leave it to someone else. Yeah. Okay, now when we talk about promoters as a person, they have a duty, so it's best to know what are their duties, right? So we have statutory duties. We also have general duties. Now, first of all, let us look at these two statutory duties and general duties. Now, as a promoter, most of the time they involve in discovering idea for establishing company. Basically, they make detailed investigation, the demand for the product, availability of raw material. In fact, sometimes they find a suitable person to act as first directors. Now, this particular happen when actually they involve someone else actually direct them to find the directors to sign on the memorandum of association. Now, can we just ignore the memorandum of association? Currently now is what we call constitution. Now, this particular promoter also involved in selecting bank, legal advisors, auditors, or even underwriters. This one for underwriters is for public companies. Now, apart from that, they also prepare the essential documents. They get all the materials to get it going. And they also provide relevant information to the judicial manager in relation to formation and management of a company. So basically, these are the duties of promoters as far as statutory and general duties is concerned. Now, there are another part which is fiduciary duties. Now, fiduciary duties are about five fiduciary duties. First and foremost, they have to act in good faith or bona fide, and they should not act in conflict of interest with the company. Second duty, they have to make full disclosures of its interests in any contract entered into by the company. So basically, if you promote a contract or a business to a company, and you have some interest in that particular contract, you should disclose. Failure which, if you don't disclose, you are in breach of your duties as promoter, and remedies may be taken against you by that particular company. Now, other than that, promoters has the duty not to defraud the company by not disclosing any affairs relating to the company. We're going to look at this case later, Ellinger and New Sombrero Phosphate Company. Now, the fourth duty of promoters is whereby the promoters owes fiduciary duties for the entire period in which he is a promoter, and however, it's a question of fact as to when he becomes and ceases to become a promoter. Now, generally, he ceases to become a promoter the moment the company is incorporated. However, sometimes they are still the promoter even after the company incorporated, but in very rare circumstances. Okay, so a person who becomes a promoter remains a promoter as long as the formation of the company continues, and it will cease upon incorporation of a company. Okay, so in this case, Twee Cross and Grant, the court held that any person may continue to be promoter even after the appointment of the board of directors, where the directors are passive and act in the interest of the promoters. Okay. Now, we're going to look into firstly on the fiduciary duties, which is disclosure of interest in dealing. Okay, now before that, this particular disclosure of interest in dealing, we must know that a promoter who stands to make profit because of his interest must disclose to that particular company his interest or any profit which he received. Otherwise, the company can rescind the dealing and make the promoter account for the profit. You can see in the case of Allenger and New Sombrero. Now, in this case, a particular syndicate purchased the island, so hoping that they contain some valuable material. So a company was later formed in order to purchase the island from that particular syndicate, right? So the leader of the syndicate nominated directors of the company at his first meeting. Company then adopt the contract, right? Basically, after incorporation, the company adopt the contract. And then the promoters is turned out to be that the company's first directors. Now, however, later on, it turned out to be that the island was worth considerably less than the purchase price. So basically, we can say that the island was overvalued. So in this case, the promoter has actually made a profit to the detriment of the company and its shareholders, right? So the House of Lords held that the company could rescind the contract. This is where your business law comes in. You remember rescind contract, right? Guarantee, warranty, try to recall those. So House of Lords held that the company could rescind the contract with the result that the purchase money was to be returned to the company and the island transferred back to the syndicate. So the promoters under a duty when forming the company to provide with an independent board of directors to whom full disclosure of promoters' interest must be made. Okay, so basically in this case the contract was voidable at the company's option. Okay, so we stop here for a while. We're going to look back into this particular disclosure of interest in dealing in our next video. Okay, so see you later. Thank you.